Hello, everyone, and welcome to today's webinar presentation, Coast to Coast Pay Transparency Laws. Across the nation, states, and even some cities have begun to implement pay transparency policies. While this employment law trend has noble objectives like improving pay equity and employee trust, it also presents employers with new potential pitfalls. During today's presentation, you'll receive an overview of these new policies and how to best navigate them. But before getting further into today's topic, I'd like to take a moment to introduce myself and my organization. My name is Stephanie Zielinski, and I'm the Marketing Director for ComplianceHR. You may recognize my name from the email invitations that you received for today's event. To prevent a few popular questions from entering the Q&A box, I would like to let you all know that this presentation will be recorded and it will be emailed to each one of you. So please keep an eye on your inbox for an email from ComplianceHR webinars. Our goal at ComplianceHR is to simplify the complexity of employment law. And to achieve that goal, we offer a suite of technology solutions around critical HR compliance topics like employee overtime, independent contractor classification, employee handbooks, onboarding, leave, and many others. Today, I would like to briefly introduce you to two of our most popular solutions, PolicySmart and the Reference Center. PolicySmart is a comprehensive handbook solution that provides you with federal and state compliant templates, a compliance policy timeline, handbook checklists, and automated emails to alert you on new legal changes as they go into effect. The Reference Center is a solution created to help you and your team quickly answer employment law and HR compliance questions. With information on a wide range of compliance topics and deep insights that bridge multiple compliance concerns, the Reference Center aims to help HR and legal professionals do their jobs more efficiently and effectively. If you're interested in learning more about our solutions, a survey should have popped up on your screen. You may have to exit full screen mode to see it. If you'd like to sign up for a demo of the Navigator Suite, simply answer yes, and I will send your contact information to our team of experts for a deeper conversation with you about your compliance strategy and whether or not our solutions can help support it. In addition to a demonstration of our solutions, you may be eligible to receive a free trial of our products so that you can see precisely how much time and money they can save you. If you're not sure in this moment, don't worry, you can always visit our website, compliancehr.com, email our team at demo@compliancehr.com. I'll ask once more before we conclude today's presentation, and you can always request more information via the link in the resources panel or in the Q&A box. Now I have the pleasure of introducing today's webinar presenters, Kelly Cardin and Joy Rosenquist, with backgrounds across a broad range of employment-related matters, including pay equity, wage and hour law, and employment law compliance. Joy and Kelly are experts on today's topic. So girls, I'll pass it over to you.
Well, thank you, Stephanie. Good morning, everybody. And when we say coast to coast, we're not kidding, right? Kelly is all the way over in the East Coast in New York. Good morning, Kelly.
Good morning, Joy. Good morning, everyone.
And I am on the West Coast in Sacramento, California, where it is beautiful and sunny. And hopefully the weather is nice for you all in the afternoon on the East Coast. So today is Equal Pay Day. So today, March 25th, is very fitting for our Coast to Coast Pay Transparency webinar. So Equal Pay Day, if you didn't know, was originated by the National Committee on Pay Equity in 1996, established as a public awareness event to really demonstrate the gaps between men's and women's wages. So it was originally called National Pay Inequity Awareness Day, and they decided to change it to Equal Pay Day. I like that better, has a better ring. Why am I telling you this? Because that is why we are here today. The pay transparency trend is not new. It is a decades-old experiment that we continue to tinker with year to year, state by state. So formally, it started with Colorado in 2021, and of course now it's spread to multiple states, requiring employers to disclose salary ranges and pay scales. So as you know, the idea behind pay transparency is to bring awareness to the pay gap, to bring that to the front of the conversation in your negotiations, to attempt to get people to start on even playing field. Sorry, it is still 9 here. I'm drinking my coffee. I will catch up. So what happens? We naturally now have a patchwork of state laws that have different requirements, and including some cities within states that have different requirements. So that leads to nuances, of course, in how you comply state by state or nationwide. Can you comply with all states at once? You can, but it sure is getting harder and harder to do that. As states develop their own specific requirements and their laws, it's getting harder to do a one-size-fits-all approach, and we can talk about that a little bit later. But here is our map. For those of you who have been with us in prior webinars, you will see this map keeps changing, right? Every 6 months to a year, it's shaded in different colors, but it is getting more and more shaded with color. So our orange are our states that have pay scale requirements in place right now in job postings. You'll notice there's a couple cities in there as well. And then our blue shaded are the states with pay scale requirements that they're enacted by the legislature, but they're not yet in effect. They've given you a ramp up period to comply. We like ramp ups. It gives us a chance to plan. It gives our enforcement agencies a chance to develop FAQs and webinars, like Illinois did a great job with that. And then separately, look at this green. These are the states with pay scale legislation pending. The green is getting, more and more popular. It's starting to spread a little bit more to the middle part of the U.S. here. So we'll be watching the pending pay scale legislation to kind of see how that pans out. So when we talk about pay or wage transparency, it's not all about posting pay scales. That is one aspect of it. Pay transparency takes several forms, and you may see it in several different forms. The first one, yes, pay scale disclosures. Now that can range from outright in terms of a job description where it has to be placed right there in the posting. Some states have that upon request, so only if the applicant requests that information. And then some states and localities have taken it a bit further to say, once you've applied for a job and you've interviewed for a job, then you're entitled to the pay scale information. So we're starting to kind of see that phase out a little bit and go more into the outright. So the pay scale legislation that's pending in green and that map I just showed you, those are all outright disclosures that would be required if enacted. So another form of wage transparency is in the form of data gathering, data sharing. Now, many of you are familiar with the EEO-1s. That's a form of pay transparency. And here in California, we have the California Pay Data Reporting every May that have employers reporting to the Civil Rights Department on what their employees are earning, broken down by demographics, right? Race, gender, ethnicity, et cetera. And so that's reported to the Civil Rights Department. Massachusetts now has their own form of pay data reporting. Illinois has a pay data certificate as well. So that's another form. Lastly, this is kind of a hybrid form, but a salary inquiry ban. So many states have salary inquiry bans. That is another form of pay transparency. What is a salary inquiry ban? It is essentially a prohibition on the employer asking for the applicant's prior salary and then using that prior salary in some way to establish or set the current salary. So 21 states and DC and several cities and counties have these types of bans in place. We often see a salary inquiry ban as a precursor before we have an outright pay disclosure law. So many states, even if they have a pay disclosure law, they keep their salary inquiry ban in effect. So you've got both of those in many states as well. So why do we have a salary inquiry ban? The idea is that it perpetuates the pay inequity. So if someone is underpaid or really not paid kind of with proper pay equity in their prior job, and that pay is used to set a salary in a new job, it just simply perpetuates that same inequity. So the concept is you can't ask. You have to negotiate based on the information you know right now, based on current skills, interview results, etc. So you can't really lump all salary inquiry bans into one because each state and city, they have their own interesting little carve-outs and exceptions. One popular carve-out or exception is whether they're asking to be paid out a prior bonus, or can I get paid, I'm owed $30,000 in a bonus, and the employer says, okay, well, let's talk about that. Can you prove that you were entitled to this? So once you start getting into contract negotiations on pay like that, it takes kind of a different form. So we are going to kind of launch into our State of the States, an overview of each state's pay transparency law, and I'm going to turn it over to Kelly to start with Colorado.
Thanks, Joy. All right, so as Joy previewed, the issue with all of these laws is that they're the same but different. So it feels like variations on a theme with all of these different state laws. But Colorado, of course, was the first state to enact a pay transparency law. And we are now in year 4 of Colorado's law being in effect. So when employers are looking for guidance or looking for strategies in terms of how to get the best cross-jurisdictional compliance, Colorado is a good state to look to in that the law has been in effect for the longest, and there's a bunch of guidance around the Colorado law. So it can be helpful, though I note that Colorado also has, I'd say, the most stringent requirements with respect to pay transparency. So the Colorado law, it applies to all employers with at least one employee working from Colorado. So once you have an employee in Colorado, the law applies to your organization. You don't need to have a brick and mortar establishment there. And that's how a lot of these laws function. The employee thresholds vary state to state, but the very rough basic idea is once you have people working in the state or enough people working in the state, that's going to trigger the law's application to the company. Colorado is currently, it was the first and one of the only jurisdictions to require application deadlines and postings that notify incumbents of promotional opportunities and post-election notices, which we'll get into a bit more, but basically these are some of the heightened additional requirements that Colorado has implemented. Colorado statute is a statute that requires the salary range, the pay range to be disclosed in the job posting, but it also requires a brief description of benefits. So typically with these pay transparency laws, it's either the salary range or the salary range plus benefits that the state is going to require be in the posting. So Colorado's both. It requires the salary range and a brief description of benefits. And when we're talking about brief description of benefits, it's typically a narrative paragraph that discusses the types of insurance that are available, whether there's a 401k matching, et cetera. And Colorado also requires there be a statement regarding other forms of compensation, so things like eligibility for bonuses, commissions, et cetera. I think Colorado was a good and helpful test case in the sense that there are a lot of lessons learned from employers in Colorado attempting to comply with the pay transparency law. So Colorado is pretty clear that if the job can be performed remotely in Colorado, then that job posting needs to have a salary range, which means that if the Colorado law applies to your company and you are posting for a remote range that could be performed anywhere in the U.S., including Colorado, then that job posting needs to comply with the pay transparency requirements. And Joy, I don't know if you see it differently, but I think, when I'm advising around this, I think that's the way most states would see it even in the states where it hasn't been challenged or pressed yet, I think it's pretty fair to say that if the pay transparency law applies to you and you're posting for a remote role, unless there's guidance to the contrary, you probably want to ensure that that remote position contains a pay range.
That's right. I agree.
Yeah, and we'll get to New York in a minute, which is kind of an interesting wrinkle, but I think generally speaking, that's the most prudent course of action. The other thing that was really interesting to come out of the Colorado law going into effect and employers trying to comply with it is that there was a test situation where some companies were saying Colorado employees need not apply to this remote role to sort of get out from under the pay transparency requirements. And that was challenged, and Colorado sorted through that. And the long and the short of it is Colorado found that it was not permissible to say something like Colorado applicants need not apply. So when I'm counseling clients, I don't advise that they try to carve out, and not seek candidates from states that have pay transparency laws just to get around it, because it didn't play out well for employers in Colorado. So those are kind of the two main lessons learned from Colorado, in my opinion. But as I mentioned, Colorado also has a lot of additional requirements that really can be challenging for companies to comply with. So one of the new requirements, so after Colorado's law went into effect, it was subsequently updated, amended, which is why I said it has a lot of the most developed guidance. But some of the new requirements that recently went into effect are pretty cumbersome for employers to deal with. So there's now a requirement that the job posting must contain a deadline for application submissions, which is an interesting wrinkle because I think historically companies were not in the business of saying this position closes on X date, right? You posted the job until you filled it and then took it down, moved on with life. So now there's this idea in Colorado where you have to include the deadline, and I think that can be a little bit challenging. There's some carve-outs that some certain postings don't have to have the deadline, but I think that this is another sort of level of complication in Colorado. And then Colorado also has this post-election notification requirement, which requires Colorado employers to send out a notice saying who got the job that was posted to employees. So I think most employers have gone about this by, sending an email welcoming so-and-so in the position of whatever the position is, to kind of make it a less awkward notification to employees. But I think Colorado's thrown up some real challenges for companies, and in my opinion, it remains probably the most difficult state to comply with all of the various requirements. Washington is its own challenge for different reasons. I'll turn it back to Joy.
Kelly, if Colorado's the most difficult state to comply with, then I think Washington is the second most difficult state to comply with. So yes. Washington's Equal Pay and Opportunity Act, yes, it's got some pretty detailed requirements. So it's still new-ish. It took effect a couple of years ago. It applies to employers with 15 or more employees with at least one employee physically working in Washington. So that's the threshold for application there. Now, generally, the job postings must include the wage scale and a description of benefits or other comp. Okay, a note about the wage scale. You will notice throughout our presentation today that the wage scale, sometimes the state just says you provide the wage scale. Sometimes a state will say you must provide the minimum and the maximum pay associated with the position. Those are different, right? The minimum and the maximum pay looks different than what is the reasonable rate of pay for this position, or what is the wage scale that the employer has determined applies to this position. Sort of a nuance there. I like the states that give me more discretion on wage scale instead of directing me to the highest versus the lowest. Okay, back to Washington. Now, Washington thankfully has defined what is a job posting. Many states don't define what is a job posting. So Washington has stated that to count as a job posting, the advertisement must include the qualifications needed for the position and state that it applies to a specific position. So this is for an accountant position. You must have a CPA license and have 3 years of accountancy, for example. Now, the wage scale or the salary range that Washington has given us guidance on is that it should extend from the lowest to the highest pay established by the employer prior to publishing the job posting. This is pretty detailed guidance that we don't often get from other statutes. So you need to look at what does this position pay previously to it being posted, as opposed to California, for example, which we'll get into, doesn't have that kind of guidance. It is, what do you think applies now to this position? What is reasonable? So Washington's put some guardrails on that. And if it wasn't pre-existing, they want you to create the salary prior to posting. That can be tricky for those of you who don't already have established salary bands. This puts you in the position of really kind of having to sort of create some salary bands prior to you posting. Not a bad thing. It's just a bit of work that you will want to embark in, and maybe look at some salary studies and work with your HR and your legal in setting those pay bands. Now, Washington State also wants you to update the pay rate if the range changes. So if you are hiring consistently, say 20% above your advertised pay range, that should be updated the next time you post, which, really tracks anyway with good recruitment efforts. What is this other compensation? Now, if the position has base pay and it's commission eligible or bonus eligible, it should state that it's commission or bonus eligible. Now, if it is 100% commission, which is not super common, right, in a lot of these postings, but if you are advertising a fully commission-based position, you have to state how that commission is based. So, for example, the example here, 5 to 8% of the net sales price per unit of home sold, of vehicle sold, etc. So the commission, if it's just commission, pay special attention to that. Likewise, if it's just piece rate, many vehicle repair shops are piece rate. Agriculture has a lot of piece rate. You need to disclose the piece rate. General description of benefits. This is really not so general. This is how Washington has kind of complicated the compliance landscape here. So for Washington, you have to disclose whether you have this long list of benefits here, as well as the insurance that you offer, the type of retirement options, the number of paid holidays, the number of PTO days or vacation days, or if you have accruals based on hours, you must disclose that. Now, why is that a pain? Because PTO and vacation, really less paid holidays generally apply to everyone, but PTO and vacation, that may vary depending on whether you are recruiting a rank and file hourly earner as opposed to an executive, VP, or professional. So it makes you really tailor each job description to fit the specific position on the benefits that you offer. Potentially same with your 401k, potentially same with your medical. You also need to disclose the amount of paid sick leave if it's more than the base legal requirement of the state. So if the state requires 5 days, like California, in Washington, you offer 8, you would need to disclose, hey, we also offer 8 paid sick days. So you can link this. That's a common question we get, but the general description has to be in the posting. The details can be in the links. Now, Washington, if you Google Washington pay transparency lawsuits, you will see a flurry of news clips because Washington, as of now, is the only state with a private right of action, which means that applicants or employees can sue for damages for violation of the statute. And we have had many, many class actions in that state based on very kind of nuanced violations. As a result, the state is enacting regulations, and they've got some pending bills here. So one pending bill, which we're very thankful for here in the business community, is that it allows for corrections to the wage disclosure in the job postings without penalties as long as you've corrected it within 10 business days. We also have pending draft rules to further clarify and define who is an employee, who is an applicant. It may seem obvious on its face, but it's really not. I mean, is an applicant someone that is cruising the internet and clicks on a job and reads about it out of curiosity? Or is an applicant someone who fills out a submission form and submits their resume? Is an applicant someone who calls about more information? So without defining those and having a private right of action, Washington has a ton of class actions that they're dealing with right now. Okay, I'm going to turn it over to the East Coast for Kelly to talk about New York State Pay Transparency Act.
All right, so I feel like at this point in the presentation, your head's probably spinning and it's feeling very stressful. And I think in terms of guidance that we can offer here, you know, it's important, I think, to take a step back and look at what these laws are trying to do, right? They're trying to ensure that everyone's entering the workforce on equal footing with respect to pay. So while it's very important to ensure that you get it right, particularly in Washington state, I think it can be a bit of a calming exercise to go back to those goals of the laws and then kind of refocus there, because it's messy, but compliance is achievable on a cross-jurisdictional basis if you kind of keep certain rules in mind and whatnot. The New York State was just a fascinating case study because when the pay transparency laws started to roll out, we had New York City with the pay transparency law, we had Westchester and Albany counties, we had Ithaca. So it was just a crazy patchwork within New York State itself. However, in September of 23, New York State implemented its pay transparency law, which requires companies to put a salary range, a pay range in job postings, and it also requires a description of the job duties. So I feel like that's been pretty easy for employers to comply with because most job postings say what the job is and what the duties will be, et cetera. So the interesting thing about New York State's pay transparency law is that with respect to remote roles, it doesn't function in the same way that Colorado's and a lot of other states function. That is, you know, once the law applies to you, if you're posting a remote role, it should have a range. New York State's law is nuanced in that it requires employers to post a salary for positions that are either performed in New York State, okay, or for positions that report to a location or a supervisor in New York. So that's kind of an interesting wrinkle there. So what New York State is saying is that, you know, if there's a job posting for, you know, a position that's going to report to a manager in New York State, but that job itself could be done in Georgia, Texas, wherever, it still has to have a pay range and otherwise comply with the law if it's going to report to a manager based in New York. And I think there's a lot of ambiguity around who is a manager, if the CEO is in New York, and that doesn't technically everybody report up into the CEO. I think there are different kind of variations and grades to when and how it would apply, but it's nevertheless an interesting wrinkle that differentiates New York State's pay transparency law with respect to remote roles. However, if you are in New York and New York City's pay transparency law applies to you, then you also have to comply with those requirements. And with respect to remote roles, it functions similar to how the Colorado rule works, in the sense that if the New York City pay transparency law applies to you and you are posting for remote roles, then that role should have a range in the job posting, regardless of whether or not it's reporting to a New York supervisor. So New York State's pay transparency law harmonized New York State's pay transparency mess quite a bit, but there still are distinct requirements under the New York City law that employers need to be aware of. New York also has pending legislation in the works that I think are worth noting here. So on the state level, there's currently a bill pending that would prohibit employers from asking applicants about salary expectations, which I think is just fascinating. So New York state has had a salary inquiry ban, one of those laws that Joy talked about at the top of the presentation, in effect for a long time. And again, the point of the salary inquiry bans is to ensure that pay disparities are not being carried forward. So if I was underpaid in my last job, that shouldn't be the baseline for setting my compensation in the new job, because that's going to keep the salary depressed. It's not going to get us to parity, et cetera. So that's the rationale there. However, for some time, I feel like this is something we counsel on a lot, but companies were like, well, how about salary expectations? Can I ask about that? And that always struck me as kind of a dangerous question, in the sense that, okay, there's nothing expressly prohibiting companies from asking about salary expectations, but a lot of times I think built into those salary expectations are what the individual has been paid in the prior job, right? The expectations likely going to be linked to what the individual was making in the prior job. So it raised concerns about carrying forward pay disparities. But there were no laws prohibiting employers from asking about salary expectations. New York State now has pending legislation that would prevent employers from asking about salary expectations. And I think that just really goes to show that, New York obviously is a state that's committed to employee rights, et cetera, but they are really trying to further pay equity and whatnot by legislating in these kind of unique ways. Additionally, there is a New York City bill that proposes pay data reporting for employers with more than 25 employees that are working in the city. Joy talked about pay reporting laws at the top of the presentation, and I think it's interesting. So when we're talking about pay transparency, I can sort of see how putting a salary range in a job posting would help to ensure that everybody enters the company on equal footing, right? If you know what the employer is willing to pay, then, you will likely be kind of set, your compensation will be set fairly and equitably. The pay data reporting laws, I think how they've been functioning, and we'll talk about it a little bit more with Massachusetts, I kind of think, and Joy, let me know if you see it differently, but I sort of think that these laws are intended for companies to sort of be doing pay equity analyses on themselves to check that their compensation practices are in line with the goals and aims of pay equity. So I think it's pretty interesting that the New York City legislature is proposing pay data reporting. The requirements of this law are very expansive and broad. There are lots of categories that employers would have to report on if it's passed. But I'm not sure if it's going to get traction, because I'm not sure how these pay reporting laws are turning out in terms of advancing the goals of pay equity. Joy, I'm not sure if you have a take on that or not.
Well, they're giving the employers big headaches, I'll tell you that. The pay data obligation is quite a pain. I don't know how far it's advancing equity, other than, like you said, Kelly, they may be discovering in reporting pay bands to certain staff that maybe certain staff are above or below pay bands, and they need to shore that up. So internally, I think there could be a benefit, but externally, it doesn't seem to be a big payoff so far.
Yeah. So we shall see what happens with this, but that's what we have going on in New York right now. And Joy, I'll send it back to the warmer and sunnier state of California. We still have winter weather here in New York right now.
It is 80 degrees here in California, and although we have mind-boggling laws, we've got the weather, okay, you guys, we've got the weather here, but I do feel you kind of rolling your eyes and shaking your head when I get to the California slide. I can't see you, but I know you're doing it out there. Listen, California is actually, on this topic, one of the easier states to comply with on wage transparency. Shocking, but true. So the pay scale in job postings just applies to 15 or more employees. If you've got 15 or more employees, at least one of which is in California, you have to disclose the pay scale. However, we have a little bit of a wrinkle. It wouldn't be a California law without kind of a wrinkle. And that second aspect of the law is that your existing employees, those already employed, may ask for the pay scale that applies to the position they're sitting in. So if I'm an accountant and I would like to know what the pay scale is that applies to me, I ask HR or my manager, hey, what's the pay scale for my job? And HR or manager has to say, oh gosh, that's a great question. I suppose we better figure out what the pay scale is if you don't already have one. For those of you that are in multi-state environments, larger employers, many of you have established salary bands. Many of you have salary bands published on your intranet. A lot of companies, really the small to medium-sized businesses, don't do that. So when they are asked by their employees what the pay scale is that applies to their position, many times it's the first time they're evaluating their pay bands. So going to the threshold here, now the statute didn't actually specify how to count the employees for purposes of coverage. It's probably going to apply to most of you on this webinar. If you have 15 or more employees and at least one of these employees is currently located in California, it does apply to you. So that is the majority. What is the pay scale that must be disclosed in the job opening? Well, first off, let's back up. What's a job opening? This is one of those states that does not define what is a job opening. So we do get questions. Does this apply to a help wanted ad? What about a social media post that generally advertises it but not specifically? So we don't have guidance here on what is a job opening. I like to borrow from other states and say if it has a specific position and there are requirements for the position listed and it has a deadline listed in it, that looks to me like a job opening. So we compare it to Washington and Colorado when we don't really have guidance one way or the other. So, didn't mean to go to Hawaii, sorry. Back to pay scale. So the pay scale in California is a reasonable range. So what do you actually expect to pay that employee? That's the pay scale in California. As you can imagine, that has a broad range of discretion afforded to you as the business on how you post that. So we do get a lot of questions here. Can you do the lowest and highest? You can if you want. That complies. Can you target the mid-range plus or minus a certain percent? Yes, if that is the range that you reasonably expect to hire in. So this is one of the states that actually has a lot of discretion built in. But let me tell you, there's a pending bill to change that. There is a pending bill in California to narrow the pay scale that you advertise in your position will have to be within 10% of the mean of what you're actually paying people in that position. So going forward, if that bill passes, talk to me in the fall, we'll have to really be narrowing the pay scale within 10% of the mean actually paid in that position. So that will be interesting. And before I jump over to Hawaii, I want to just address the pay data that Kelly was talking about previously in New York. So New York is thinking of implementing pay data requirements. In California, every May, we are disclosing pay data to the Civil Rights Department for employers that have 100 or more employees, at least one of which is in California. You are reporting pay data to the Civil Rights Department. So that is currently in effect. We're on our third year of pay data reporting. If you think pay data reporting applies to you, Littler has a whole separate webinar on this that I've done with Chris Gopturk. Many of you are familiar with her. She does EEO1 reporting. So reach out to me if you need that, because we are in our waning weeks before the reporting. So it's not too late if you need advice on that. And I am going to turn it over to an even more beautiful state, Hawaii. Wish I was there right now.
I also am not there right now. We can move a little bit faster through these next couple of states because a lot of the requirements you'll see are kind of similar to the states we've already discussed. So Hawaii's pay transparency laws took effect in 2024, And this is a law that requires companies to disclose an hourly range or a salary range in the job postings. Hawaii's done some favors in clarifying that this doesn't apply to employers with fewer than 50 employees company-wide. So that's some kind of helpful guidance there as to who it applies to and who it doesn't. And it also does not apply to internal transfers or promotions or public employees. So I think Hawaii is a pretty straightforward state. Illinois is less straightforward. This law took effect this year in January, and it is a law that requires a pay scale and benefits disclosure in job postings. You can see that Illinois has kind of borrowed from the New York State statute in the sense that it requires positions reporting to a supervisor or an office in Illinois to comply with the pay transparency law. Illinois is also a state that enforces its pay transparency law by penalties, by civil penalties. During a Department of Labor webinar, the Illinois DOL clarified that there is no private right of action under this law. So this is not a Washington state situation where companies will be getting sued or anything. It should not function in that way. And they also clarified that there is a 14-day grace period to bring any non-compliant postings into compliance. And that's sort of a helpful thing, obviously, for employers. And I know Joy was talking about Washington also potentially implementing something like this. New York City has this as well, where if you bring the job posting into compliance with a certain amount of time after being notified that you're not doing it right, the agency won't assess penalties. And quite frankly, I think that this is how these laws should function. I think that when they get overly punitive, they're not particularly helpful to anyone. So I really think that these states that have these grace periods for compliance are kind of doing it right. The other thing to note about the Illinois law, and New York State also has something similar, is that the job postings should clarify if there are local ranges for a role. So the example here is if there's one range for a position that's being performed in Chicago and another for the position that's being performed in Champaign, the job posting should reflect that to ensure that candidates know which range would apply to them if they get the job. All right, Joy, I'm sending it back to you.
All right. Washington, D.C., where the cherry blossoms are blooming at the moment. Let's talk about the nation's capital. So this took effect, let's see, we are almost a year into this law. It took effect last June. It covers all employers with at least one employee in D.C., so you can see that trend here. And D.C.'s law requires you guys to disclose the minimum, maximum projected salary or hourly pay in the job listings. So here's one of those requirements that doesn't just say range, they say minimum, maximum projected salary. So this also requires disclosing to applicants the existence of healthcare benefits that you may receive. So once, it doesn't actually have to be in the posting itself, but once you get applicants, you then have to disclose healthcare benefits. That seems to me a little bit tough to kind of operationalize with your HR. I would probably just put the benefits in the disclosure so that doesn't drop through the cracks there. And thankfully, there's no private right of action in this law. As we said, it's Washington State that has the private right of action. So the steepest kind of compliance pitfall really is Washington State because of that private right of action and the attorney fees. Washington, D.C. has no private right of action, and of course they can assess fines. Also, I'm going to turn to the next state here, but I wanted to address, there's a couple of questions that are popping up quite a bit in the chat about evergreen postings. Evergreen postings are job postings that are open until filled that have no deadline. And many of you are asking about Colorado. So Colorado does have an evergreen exception. in terms of they will allow employers to continuously accept applications, but the posting has to state that there's no deadline because applications are accepted on an ongoing basis. So it is an exception to Colorado's deadline requirement, but you just have to comply with that regulation, essentially that states it's ongoing, et cetera. So definitely refer to the EPEWA rules there. Okay, back to Maryland. So this just took effect last fall. So we will kind of see how this shakes out. I haven't heard much enforcement coming out of Maryland. So Maryland's law requires employers to disclose the wage range and a general description of benefits and other comp. What's other comp? Usually that is whether this is some sort of incentive compensation or a bonus is available. Maryland was nice enough to clarify that it applies to both internal and external postings. Many states differentiate between external postings and internal, but some states don't. They just say job posting, which kind of leaves employers to say, well, does this apply internally? Generally, it does. If you are posting a job, even if it's internal, I would assume that a state wage transparency law applies, unless it specifically calls out only external job postings. So Maryland applies to internal and external. And this is an interesting little requirement here. The law includes that the disclosure of board, lodging, or other advantage provided to an employee for the convenience of the employer. So if you have lodging included within the position, that's something you need to disclose in the job description and job posting. So that's actually in the wages definition itself. Very interesting there. So penalties range from a warning letter for a first offense to a $600 fine. Something I didn't mention earlier, California also doesn't necessarily do a warning letter, but it does give you a mulligan. So you get a freebie for first violation. So moving on then to the FAQs. Maryland has done FAQs, which is great. Employers have to include a pay range and general description of benefits and any other comp offered. So we've covered that. And they have stated at least that the law applies to a posting for any position where the work will be physically performed, at least in part, right? That addresses, does it apply to remote or not? Lastly, some more FAQs from Maryland is the law doesn't specify how employers have to recruit. So if you post either externally or internally, then you have to disclose certain specified information, but it's not telling you, okay, you can't use executive recruiters. You can't recruit this way or that way. So that's a nice clarification. And I won't really read this entire section here on the penalties. You can refer to that if you need to. I want to move on to Massachusetts. So Massachusetts is giving us a ramp-up period. It doesn't take effect until this summer. So it applies to employers with 25 or more full-time workers in Massachusetts. And the pay range here, again, you have some discretion, is what the employer reasonably and in good faith expects to pay. That's much different than minimum maximum, what you reasonably and in good faith expect to pay. They've also defined what a posting is. And then here on the penalties, again, we're getting a warning for the first offense. This is good. We like these warnings. It tells us how a state is enforcing their interpretation of what is a violation under the law. So those warning letters really guide our future compliance. Again, as Kelly mentioned, there's a pay data reporting requirement. It used to copy and paste California's requirement. They amended it right before it went into effect and struck all of that and said, we will just be providing a copy of our EEO-1 to the state authorities. So very different type of pay data reporting there. And that's it for Massachusetts. Kelly, you want to finish us off on the states?
All right, we're almost there, everyone. So Minnesota's pay transparency law went into effect this year. This is a statute that requires there to be a pay range and a description of benefits in job postings. We also have New Jersey's pay transparency law, which will take effect in June. I think the wrinkle or the complication with New Jersey is how we are going to count employees to understand whether or not the law applies to an employer in Jersey. So the formulation is that it applies to employers with 10 or more employees over 20 calendar weeks and to do business, employ people, in New Jersey. So this is obviously a little bit ambiguous, but we expect that the enforcement agency is going to take the position that employers with 10 or more out-of-state employees are still subject to the bill's posting requirements. So we'll see. I don't think we're just going to be counting Jersey employees, but it's a complication. And I think that's a fair way to assess all of these laws. They're all very similar, but with their own little complications along the way. There are also a few additional requirements in the Jersey law. So this is going to be a law that requires there to be a salary range disclosure and a general benefits description. This law is also going to require employers to make reasonable efforts to announce, post, or otherwise make known opportunity for promotions. So this is the idea that kind of goes to what Colorado is doing. Illinois kind of picks up on this, but this advertising promotional opportunities is also something that we see in the Jersey statute. And we expect that this is going to be a statute that is primarily enforced through an agency, not through private litigation. So hopefully that will remain the case. And then just to make sure that this is on your radar as well, Jersey City has had a pay transparency law that's been in effect for quite some time. So just to make sure that you are aware of that law in the event that you do business in Jersey City. And finally, we are at Vermont, which has a pay transparency law that will be taking effect in July. This is a law that requires you to disclose compensation and a job description. So this Vermont law is similar to the New York state law in this whole business that it requires a description of the job, and then also it limits its application to jobs that are going to be performed in Vermont or that report to a supervisor office or work site in Vermont. So picking up on that New York, Illinois language as well. So it is an interesting state of the state, I think. And, we'll talk through some cross-jurisdictional compliance strategies here. Joy, do you want to quickly talk about the pending legislation, as this seems to be an ever-evolving area of the law?
Yeah. No kidding. And speaking of pending legislation, when I had mentioned Massachusetts got amended last minute to strike all that pay data stuff, they also changed the effective date. So Massachusetts actually goes into effect October 29, 2025. That was edited last minute, not July 2025. So those of you in Massachusetts have until late fall to start compliance, and we'll update the slides before we send those out. So pending legislation, interestingly, in Ohio, I just wanted to call out, Ohio will have their third city have pay transparency legislation, but not the state. So at some point, maybe that'll take over critical mass, who knows there. But Washington and New York, we discussed those amendments already. Those are forthcoming. But all of these states will require affirmative pay disclosures in their job postings. So these are not just salary inquiry bands. They're not only upon request, they're affirmatively in postings. Okay, what's an employer to do? Well, as you can see, compliance is tricky. Nationwide compliance is really tricky here, especially when we talk about virtual work, which is filling up a lot of the chat. It's just harder to advise in this space because despite the fact that we are many years after COVID and we are in a virtual world, some of these statutes just simply don't tackle the issue of remote work. Some of them do in guidance issued later on, but there's a gap meanwhile. So the pay, generally, as Kelly discussed, the pay transparency law applies to the position where the job is performed. Okay, this we know. Now, if it's not clear for a virtual position, the location where the person intends to perform the job, one thing you can do is include a question about where the applicant's going to be working from. So get information in that application process. It will help you guide your compliance. Another point we like to guide employers on is that you can actually tell your applicants or new hires that they are approved to work from a certain location, but they need advance approval to move to other locations. Because yes, although you don't conduct business in all jurisdictions, you also want to know where your employees are sitting so you can be complying with pay transparency laws, and you need to know where that worker is performing their job. So if you have specific questions on the virtual work, please reach out to us. Also, this is kind of just a recap of that salary inquiry ban that we had talked about. Try to avoid discussing that wage history, and yes, discuss your salary expectations, except for New York. Be careful there. If that law passes, you want to maybe even avoid that conversation, which really provides for kind of an awkward encounter, but we're hoping for some guidance there. And then let's see, strategies for posting. Do you want to wrap us up with some strategies, Kelly?
Absolutely. So I think when you're thinking through your compliance strategy, it's important to understand the risk that you're potentially facing and where physically that risk is. So as Joyce and I have both said, I think several times, Washington State is really the greatest risk because of these class actions. And just so you understand, the way damages are calculated in these cases is that it's an applicant's actual damages, which who knows what that would be if they could even be proven, or $5,000, I believe is the way the statute's written now. So because there's this sort of amount set in there, plus attorney fees, as Joy mentioned, Washington State has the most risk in terms of what happens to the company if it gets pay transparency wrong. So when you're thinking through how you're going to comply, you can have a strategy for cross-jurisdictional compliance. You just need to understand the risk and what risk you're taking on by sort of doing it one way versus the other. So I think that some states like Washington require there to be an actual range disclosure. So I think getting that piece right in the first instance is really important. But I also think it's important to think through who is it you're trying to hire. So you might be looking for an entry-level HR generalist, for example, and you're thinking of paying that entry-level individual at the lower end of what you're currently paying all of your HR generalists now. So in posting the range and in making the post, you should really think through and consider whether that entry level should be considered a distinct and different position from the HR generalist you currently employ, to ensure that you're getting it right with respect to the pay transparency laws, and that you have a viable defense in the event anyone ever challenges what you've posted in the job posting. Let's see what else we've got by way of compliance strategies. I think another very important thing to do, and I think a lot of companies have been great about doing this, is ensuring that you are doing privileged pay equity audits on the front end to make sure your pay equity, your pay practices are aligned and you're comfortable with where they are, and then going from there in terms of setting salary ranges for various roles. Doing this exercise can ensure that you avoid a lot of issues on the back end, because I think one of the biggest risks with these pay transparency laws and where employers face risk in potentially getting it wrong is if whatever range they're posting in the job posting, the job advertisement, causes a current employee to think, wait a second, am I being underpaid and why? So I think there's greater risk or significant risk in having ranges that don't align with your current pay practices, because that can open you up, potentially expose you to litigations from current employees who are not happy with what they're being paid as compared to what's being posted in the job advertisement. So I think really having a comprehensive strategy is important, and then ensuring that your HR people, your recruiting people, and your managers are educated on these laws is important as well, because some of these states do have the requirement that employers provide salary ranges to employees upon request. And if your workforce is asking managers for the salary range and the managers don't know that they have an obligation to either give the information or direct someone to HR to get the information, that could be potentially problematic from a litigation perspective too. So we've given you some kind of tips here to evaluate your internal practices and training. But again, I know this is all very overwhelming given the nuances. Really, what these laws are trying to do is to just ensure that pay practices are fair and equitable. So if you ever feel yourself kind of getting overwhelmed with all of it, I think going back to that initial question of what do I plan to pay the candidate who gets this job can be a helpful tool. And with that, I will send it back over to Stephanie to wrap it up.
Kelly and Joy, thank you both very much for providing us with this comprehensive overview of the new pay transparency policies and how employers can best navigate them. Before we conclude today's event, I'd like to offer one more opportunity for attendees to register for a demonstration of the Navigator Suite. So you should have a poll popped up on your screen. Again, you may need to exit full screen mode to see it. With all of the possible pitfalls of employment law compliance, it's critical that you don't leave your compliance strategy up to chance. Our solutions are designed to support employers like you while saving your organization time and money. Again, thank you all very much for taking the time out of your busy schedules to attend today's webinar. We hope you enjoyed the content and have a great rest of your afternoon.